I will read the one part of Jerry's bio that I like. While I've done teaching and seminars in both technical and legal aspects of surveying, I really enjoy presenting and learning more about the legal side, which is tonight's presentation. How boundaries were created, actions people took with respect to them, and subsequent reestablishments are the footsteps the contemporary surveyor must follow. A lot of that particular paragraph really goes into tonight's presentation. So I wanted to keep it brief because Jerry's on here a lot, and I know and he's up to like four retireds now. Every time he puts his
Just let me share my
presentation
screen
together.
once. Let me share my screen once.
Sorry, 1 second. Whoops, hold on. Where the heck am I? Back, and then I'll share Jerry's slide deck. It's on his website. You're good to go now. Um, his slide deck is on his Jerry's personal website, and he's got a whole section for Mentoring Mondays on there, and I'll throw that in the chat right now for everybody. There you go.
Okay, I got my screen there.
You are good to go.
All right.
Oh,
Yeah,
that's
so
only
I am
three. It's only three retired. You're gonna have to add them
23. Well, it's three retires. I'm working on a fourth.
all.
I mean, if anybody says retiring is hard, it's not. It's easy. I've done it three times. Okay, so it's a piece of cake. And if you looked at the website, you saw that I had my slide deck up there, but I didn't have a homework assignment for you at this time.
Oh,
So
I meant to say that. It's
so
the first
instead, I
time.
decided to do a pop quiz.
Ah,
Now,
perfect.
this is a true false. It depends. A lot of questions here. So I did this presentation at the Wisconsin Society of Land Surveyors Institute this last spring, and I geared it primarily towards Wisconsin common law and statute law and stuff. And I kind of wanted to make it a little bit more generic with respect to this presentation because it's
Sure.
so different across different jurisdictions. So I actually did dig around a little bit and find some other statutes and some other case law and stuff, but it's nowhere exhaustive with respect to that. So, but let's just burn through this real quick and let's see. This is kind of like a pre-test. Based on his or her quasi-judicial capacity, a surveyor is able to render a boundary decision where adverse possession is involved. Who wants to answer that one?
False.
False. I got a false there. That's kind of a quiet false. Or somebody's a false. Okay. There must be intent to possess for an adverse claim to ripen.
True.
Somebody has to intend to adversely possess in order for them to adversely possess. They have to intend to.
Mark said true.
True.
Yep, there you go. Got a couple
Yeah, true
trees.
there. A court decision in a successful adverse possession case will result in new property descriptions.
Yeah, should be a true.
I got a false up. I got a thumbs up. The required time for adverse possession is
Yeah.
That's on the state.
Yeah.
you're starting to get the pattern here, right?
That's
The
right.
same party must initiate and maintain the possession through the entire required period.
False.
No.
Publicly owned land cannot be adversely possessed.
That's true.
Yeah.
Okay, see, we got a lot we're going to learn tonight. Possession based on a written document is called what kind of possession? There's a specific legal term for that. There's two kinds of possession legally. See, we're on the dark side now, so we got to think of this in terms of legal terms, not just
Like
surveying terms.
fee simple or fee
Be simple.
possession?
Be simple. Okay, a seemingly good deed which contains a description defect is said to have blank of title.
Cloud.
Cloud.
Yeah.
Caller.
Hostile
Color.
generally requires intentional overt action.
True.
Hmm. Well, let's see. Let's sort through some of these things here and see what happens. Okay, we'll go through some basic principles here, and I kind of like to use. I always used to grab when I taught this in class in the face-to-face class. I'd always find a student that had some really expensive phone laying out or something like that, and I'd pick up his phone. I'd use that as my example. But let's say I buy a truck. I receive a written title, okay, a piece of paper. Who owns the truck?
Depends on if
Who
there's a
owns it?
loan against it.
Well, I own it.
You
Technically,
own
I
it.
own it.
Okay, there you go.
If
Well,
if your
the
name is
bank
on
might
it.
have a lien. If I've got a loan on it, the
Yeah.
bank will have an interest in it, so there'll be a lien on it. But
Right.
technically, I own it, right?
Yeah.
So it's my truck. I love my truck. Okay. So I have title, I have ownership, and I have possession of that truck. I possess it, I own it, and I have a piece of paper that says it's mine. Okay. So I get this disreputable youth from down the street, breaks into my truck, and he drives off with it. He steals my truck. Who has title?
You do.
Right? Who has possession?
The thief.
Yeah. Who has ownership?
You do.
Okay. How long? Okay. If somebody holds my property long enough, or my personal property, my car long enough, they can gain ownership of it if I don't bring action or I don't find them within some statute of limitations is generally what's used. So at that point, then it becomes moot after that. So I might have title, but he has possession and ownership of it. Okay. Now, the statute of frauds came about back in 1677 for some that said some contracts had to be written to be valid, and that included contracts for sale of property. And the reason we have a statute of frauds is that all the terms and conditions are reduced to writing, so the original intent is clear. No one can go back on what they said later on. So it's clear not just to the two parties involved, but any other parties that may have an interest in it. The document stands on its own without having to ask either side what was meant. Okay. Now, sometimes we have to revert to what's known as extrinsic evidence to clarify some terms of the deed, but we can't change, a contract. We can't change the terms of a contract. So a deed is a contract for land transfer, and a description is the subject matter of the deed. And that defines what the grantor conveyed to the grantee. Those are the written intentions of the parties. So when we say we have to reestablish property boundaries based on the written intentions of the party, that's what the deed is. We can't look at the deed and say, well, what they really meant was is what's there. And we're supposed to give effect to as much effect to all the words as we can. Now, a deed doesn't have to be recorded to be valid. It only has to be delivered. And I'm not sure if that's true in all 50 states. But recording a deed is a form of constructive notice. And what that means is it's put in a public arena where anyone's got an interest in it can look at it and see it. And then it becomes part of a chain of title that's traceable. Okay. Now, land can only be conveyed by written document. Every state has got a statute of frauds and has got a statute on contract law and that and says land has to be conveyed by written document. Mm-hmm. It can't be conveyed in any other fashion. Well, it's important that there's to have the conveyance between two parties. Now, the land and the trucks.
No handshakes.
Question?
No handshakes.
No, we'll get to that in a bit. Okay. Land and truck situation can be similar, except title has a different meaning. Okay. The title, when we look at for a vehicle, we normally think of that written piece of paper that we get from the DMV, right? But a title in a legal context, if we look at the definition from Black's Law Dictionary, is the union of all elements, ownership, possession, and custody constituting the legal right to control and dispose of property. So it's more than just a piece of paper. In essence, the deed is the piece of paper where land is concerned, where the title is a piece of paper where the truck is concerned. Now we have things like grand theft auto, but we don't have grand theft property in that context and stuff. So the deed and the possession are evidence of title. They're not proof of title. Now, when we talk about corners and lines, I tend to break this into three types: the deed, the possession, and the ownership. The deed is defined by the written description in the deed. That's what the written intentions of the parties were. Possession is to where use or control takes place, and ownership is to where legitimate bona fide rights exist. Now, ideally, all three coincide. And when we first create a parcel of land, say like a lot in a subdivision, all three of those things coincide. But over time, based on the actions of people, those things can separate. Somebody starts using land that's not theirs. And if they use it long enough, they can gain an ownership right. So all of a sudden we start to get the separation between those three different sets of lines. Now, an unwritten right is ownership that's obtained without benefit of a written document or is based on a defective document. And it's generally the result of an informal agreement and or inaction of affected parties. Now, the question that came up about handshake agreement. That's an action between two parties, okay? Now, that means an unwritten right where ownership can change, but a conveyance can't take place because it doesn't meet the statute of frauds, okay? So we'll see how the courts play with that definition. But land transfers predate written documents. Before the statute of frauds came along, it was traditional that the grantor and grantee would walk the exterior, point out and touch corners or features, and there might have been witnesses present. So everybody knew what was being conveyed. Over time, successive owners were further removed from the original intentions, creating boundary uncertainty and animosity between adjoiners. Now, if you've purchased any property in your life, when did you meet the grantor? That's where you jump in with an answer. When did you meet the grantor? At the signing, if then, right? Okay. When you all sat down there and you started writing checks to everybody, strangers passing by on the street and that type of thing, you never went there ahead of time and with the grantor walked the perimeter of the land. At best, you walked it maybe with that grantor's agent, who was a realtor. Mm-hmm. And that realtor in most jurisdictions is protected against providing false information because they're acting as an agent on the part of the grantor, and they're not guaranteeing that the information that being presented is correct. If you ever have a weekend where you got some free time, go out with a realtor. Don't tell them if you've got a surveying background, and just look at some vacant land. And in the middle of everything else, say, well, where the lines run on this? And some of the people they'll pull out a description. They'll give a very detailed description of the fault line. Others will say things like, see that tree over there? Right along that fence over here to the water, down to the road there, across over there, and then see where that telephone pole is? Yeah, it's lines up around. You'll hear all sorts of things. And they're not liable for that, but that's as close as we get to walking the perimeter and touching anymore and that type of thing. So that's one of the reasons the statute of frauds came about, is so that all those terms could be written down and all the intent could be memorialized in a written document. Yeah. Now, the English law, our common law is rooted in feudal principles, recognize that two adjacent owners could reach an arrangement to an uncertain boundary by agreement and by action. It wasn't so much, I'll give you this land, you give me that land type thing, as it is, we're not exactly sure where our ownership extends to, but we'll reach some sort of agreement. We'll do some sort of action that says from this point forward, we're going to use this as our common boundary. And that served to stabilize uncertain boundaries and protect the person who acquired interest in good faith from another. Because someone else comes along as a grantee later on, and they got to get rights from the grantor, and they want those rights to be, as stable as possible. So the English common law, the landowner was expected to protect, defend, and preserve his ownership rights. And someone else who possessed and defended the land could gain ownership if they acted more like the owner than the title holder did. Because they're basically saying, the real person who holds title doesn't care enough about the land to defend it. And someone else is going to come onto that land and make it more productive and act like the owner, that that person got favored status in that respect. So how does this square with the statute of frauds? If somebody can gain ownership through actions of parties and all that kind of stuff, well, this is a typical decision. This is Skinner v. Francisco from Illinois Supreme Court in 1949. But it says it's a familiar doctrine of law that title to real estate cannot be transferred by parole, that is unwritten means, or is equally forbidden by the principles of common law and express provision of statute of frauds. But such an adjustment of the boundary, if followed by corresponding possession, may be binding on the parties to dispute, not because it passes title, but because it determines the location where the state of each is supposed to exist. So basically, the court doesn't look at this as a title transfer situation, but as a title clarification. The two parties, through their action, whether it's through acquiescence or equitable estoppel, there's a number of different methodologies, their actions cause there to be stability in that boundary. And the ways that we can do that, it could be either a hostile or peaceful relationship between the adjoiners. It could be by adverse possession, acquiescence, sometimes referred to as recognition and acquiescence, equitable estoppel, and parole agreement. And each of those are unwritten methodologies. And we're just going to be talking a little bit about adverse possession tonight. And good fences make good neighbors, right? All right. Once established, unwritten rights are binding on the parties to the situation and subsequent owners, because the passage of rights is happening from grantor to grantee. So any of the rights that are created through an unwritten means is binding on those parties and subsequent owners. All right. So people are most familiar with adverse possession. I think they are. And then I've encountered clients that, I say, well, it looks like, there might be an issue with that, where that fence is. Oh, that's my land by adverse possession. I've had the fence there for 30 years, so that's mine by adverse possession. So everybody knows what it is. But what it is, basically you're using someone else's land long enough without their permission to gain ownership of it, okay? Wisconsin Supreme Court decision 2014 was reiterated again, as it had in the past. Adverse possession is a legal action that enables a party to obtain valid title of another's property by operation of law. And inevitably what happens, I didn't put it up here, but somebody will be burned by this, and they'll talk to a legislator and they'll say, that's not fair. They stole my land. We need a law against this. And then the legislator says, I will look into that. And as soon as they do, they'll see that we have a law on adverse possession, which guarantees that adverse possession can happen if certain conditions are met. But somebody always gets ticked off and they write to a legislator, and the legislator is going to fix it all and that type of thing. And it never gets anywhere. Okay. Adverse possession arises from common law, but most states have adverse possession statutes defining the requirements. And I got a couple of them there: Nebraska, Washington, Colorado, Florida, the ones I looked at. I can't remember which one it was, but I know one state I went into, and it did not have anything on adverse possession as the requirements and all the who's protected and all that. The only thing it said about adverse possession was in transfer of property by written document. It says that only those rights that the grantor has may be passed. Any loss through adverse possession are not passed. And that's all it said about adverse possession in the state statutes. So the degree of that means basically you got to go into the common law, see what the common law requirements are with respect to it. But the general requirements are, these are the primary elements that have to exist, that have to be met by the adverse possessor in order for adverse possession to take place. There has to be possession. There must be use. It must physically occur. It can't just be you sitting there thinking about how nice it would be to use your neighbor's land. It can't be hidden. The title owner has to have opportunity to see. They have to have the opportunity to see it. Someone else is using their land. It has to be exclusive, which means that the possessor acts as the owner and doesn't share that use with anyone else. What's a prescriptive easement? Anybody know what a prescriptive easement is?
Just a
Come on,
right of
no.
use.
Say again?
It's a right of use that ripens over time, just like adverse possession.
Yeah, it's similar to adverse possession, but the big difference is there's two differences between a prescriptive use or prescriptive easement and adverse possession. One, it's only the use that is gained. It's not the underlying fee. The underlying fee still belongs to the title holder. And secondly, it's not exclusive. Adverse possession means it's one party holding or using another party's property. Whereas a prescriptive use, it could be a number of people. And a common one for that would be like the public is using a walk across somebody's property. It's not an exclusive use. Many people are using it. So the differences between a prescriptive use and adverse possession is the degree of ownership rights that are exchanged and the fact that there's a non-exclusivity with respect to prescriptive use. Okay? Hostile just means it has to be against the title owner's interests. And continuous, it must be uninterrupted for a specific period of time. Now, what's hostility? We looked before at one of the questions, what's hostility? Is that required overt action? Well, we've got a bunch of different court decisions here that kind of go all over the place. Hostility, this is in Washington. Hostility is defined by this court does not import enmity or ill will, but rather imports that the claimant is in possession as owner in contradistinction to holding in recognition of or subordination to the true owner. In English, it just means if someone's using someone else's land, that's an act of hostility. It doesn't have to be that there's any fighting or yelling or screaming or anything like that. Hostility means just the fact that you're using someone else's property. That's hostile in the eyes of the court. In the Wisconsin Supreme Court, defendant here claims that the use of the road by plaintiff was not hostile. But our court has made clear that hostile does not mean unfriendly intent or require a manifestation of ill will. Rather, as an act is hostile in this context when it is inconsistent with the right of the owner and not done in subordination thereto. And Ohio, 1985, the hostile use here began as soon as Van Estelle took possession and began using the property as his own. So just the mere fact of using the property is hostile in the eyes of the court with respect to the title holder. So you got to remember, adverse possession is an ownership claim against a title claim. It's not really a person against a person, okay? What happens is if adverse possession matures and ripens and becomes a right that's associated, it's associated with the property, not with the person. So that when that property passes to the next party, that right goes with it. It's not just invested in that one single party. So that means that either the title holder or the advanced possessor can change without affecting the adverse possession. That's a concept known as tacking. Tacking means one person adding on to or tacking their time onto a previous one. So we can have a situation like this. Let's say it's 20 years is needed to meet an adverse claim. So in 1982, Smith initiates the adverse situation. He builds a fence onto Jones's property. So 1982 it begins. Okay. In 1992, Jones sells to Black. Okay. Now, Smith is still using at that point. Smith is still the adverse possessor. Now, there must be privity, a legal connection between successive owners. And so when Jones sells to Black, generally he's done using the deed. So, Black inherits or gets the situation from Jones. In year 2001, Smith sells to Kelly. So it's in the 19th year of possession now. So basically, if there's privity between Kelly and Smith, Kelly can tack his time of ownership onto Smith. So Smith's already accumulated 19 years. Kelly can go one additional year and fulfill a 20-year requirement. So at that point, then, Kelly has adversely possessed against Black. Neither one of them are original parties to the situation when it first started. So it's an ownership claim against a title claim. Okay. So now when Kelly, because he's successful, he gets that through a court action, a quiet title, once sells his property, he has title up to basically that fence or whatever that occupation line is, and Black has lost that. So he can no longer convey that little strip that's under. Now, there's a couple of differences in different states with respect to this. Constructive possession, that was one of the questions, is based on a valid written document which contains a defect. A deed with a defect is said to have color of title. By that means it looks good, but there's something wrong with it. And that's like a latent ambiguity. We don't know if there's something wrong with the description. It looks good until we try to apply it on the ground. So let's say that Smith, the junior owner, has got the east 200 feet. Jones, the senior owner, has got the west 200 feet, but there's only 397 feet to go between those for the original parent parcel. So that means somebody's got to get shorted out of 3 feet. Right? Well, if we did it strictly on senior and junior rights, who gets that 3 feet?
Senior.
Jones.
Jones.
Jones does, right? Senior owner in the case of an overlap gets that, right? Rules of construction. Right? But now Smith, believing he really owns 200 feet, acts with respect to that 200 feet. So he's doing it based in good faith. So in a case like that, he's using as his justification, not intent to go out there and grab land from Jones, but to take land that he actually believes is his. It's 200 feet. That's what his deed says. Now, in some states, it says that the adverse possession can only be tacked if there's a color of title situation. So if we go back to this situation here, if Smith had the junior title and Jones had the senior title, and Smith goes onto that land, then the other guy can tack onto it because Smith really thinks he owns 200 feet because he's got color of title. But if Smith just goes at large on that land, actual possession as opposed to constructive possession, then he can't convey to Kelly, there's no privity there because he doesn't have any right in there based on a defective title. So in Wisconsin, that's not the case. In other states, it is the case. So again, depending on what it is in your particular jurisdiction, tacking may or may not occur depending on the nature of the possession. Actual possession is going at large on the property and using it without justification based on a defective title. For instance, Black builds a garage that extends over Brown's property line by a couple of feet. So at best, what he can adversely possess would be the area that's underneath the garage. He wouldn't get anything else because that's the only part that it's using. But if he built this garage, believing that he had 200 feet to work with here and that line went through here, then he would have constructive possession. You see why this is becoming a legal thing and not a surveying thing? See, okay. And because the tacking situation in a case like this, in some states, Black can have his time tacked on to the grantee, but in some states they can't because of the actual possession versus constructive possession. Okay. This gets, any use outside the deed cannot be tacked on by the subsequent owner. But, okay, if the adverse claim ripens by Black, and he does it for his 20-year period or whatever, then he gets the claim and he can convey it once he's got it. But he can't tack it. The subsequent owner can't tack it if it hasn't ripened yet. So it gets pretty confusing real soon. Now here in Wisconsin, this is kind of interesting because we have 3 different time periods for adverse possession based on the situation. For instance, ours is 20 years if it's not founded on written instruments. So that's actual possession, not constructive possession. It's founded on written instrument, that's color of title, constructive possession, 10 years if the title is recorded within 30 days of initial entry. So by recording the title and then entering on it within 30 days, then it's only 10 years. Broader range of acceptable occupation evidence. Founded on written instrument and payment of taxes based on constructive possession, titles recorded within 30 days of its execution, not within entry, and the use is uninterrupted for 7 years and taxes are paid on it. Now, chances are really good that if you've got color of title, you're paying taxes on the property because if you've got a 3-foot overlap with the neighbor next door, the assessor's not going to care about that. They're going to charge you the full 200 feet or whatever for taxes and that type of thing. But we have 7 years, 10 years, and 20 years. Okay? So we have 3 different periods in Wisconsin. Some states have 20 years, some states have 30 years, some states have 5 years with payment of taxes. Right? Depends on your particular jurisdiction. Yeah, Colorado, 5 years in payment of taxes. Florida, 7 years based on color of title of recorded deeds, 7 years with payment of taxes and public liens without color of title. Washington, 7 years based on color of title and payment of taxes, 10 years on forest lands with substantial improvements, which I assume are natural reserves and that type of thing. And Pennsylvania's is 21 years, regardless of the situation. Must adverse possession be intentional? Do you have to intend to adversely possess somebody's land? The harsh truth is rules soon became apparent in many jurisdictions. The courts began to hold that land could be acquired by adverse possession, even though adverse intent was absent if the true owner acquiesced in such a possession for 20 years. So if the owner didn't do anything about it, that was possession. Okay. Although he openly claimed and used the land as his own for well over a statutory period, we held that he never formed the requisite hostile intent because he would not have claimed the land at his own had he known it belonged to his neighbor. So this one here says there is no adverse possession because he didn't realize it did belong to somebody else. So he didn't intentionally do it, so therefore he didn't get it by adverse possession. In Colorado, the mere possession of land beyond the real boundary line is not sufficient to make such holding adverse. There must be, in addition to that, an intention to claim title to disputed area and to hold that as the owner. So this one basically means grand theft land. You're going onto the land, you're going to use it, you know it's not yours. So you can see that it varies quite a bit depending on jurisdiction. Who's protected against adverse possession? Well, it's basically the title holders who are unable to defend their rights. And these include parties with a handicap. And by handicap, we mean something that prevents their recognizing that rights are in jeopardy. If the handicap is removed, so is a protection. Okay. So, for example, a minor who gains ownership through an inheritance, they're protected while they're still a minor against being adversely possessed against. But as soon as they reach the age of majority, that protection is no longer there. Most states include that. Person is under the age of 18 years. Person is insane, okay, legally insane. And person's in prison for a term less than life, okay? You're not protected if you're in prison for life. How about an absentee owner? We have a lot of land in northern Wisconsin that's on lakes and stuff. And we got a lot of people from Illinois that buy land up there. And we got a lot of people from Minnesota that buy the land up there. What if somebody adversely possesses against them? Can they claim their handicap is that they're not there to see it? Would that be a legitimate claim as a handicap? I'm prevented from seeing that I'm being adversely possessed against. No. No, because if you can't visit your land in 20 years or whatever, you're expected to defend your domain. So the fact that you're not there to see it is not a handicap under the eyes of the law. So therefore, it's not viewed as a legitimate adverse claim buster. In
But
some states,
I'm so sorry.
yeah.
So who establishes the or qualify as a handicap then? How does that work in a case like this?
Well, outside the ones that are statutorily defined, because these are statutorily defined in most jurisdiction. If it's anything outside of that, then that's whoever makes the strongest argument in court that there's something that prevented them from being able to view that they were prevented from seeing that their land was being used.
Okay, I see. Okay, got it. Okay, thank you.
See, this is why we're on the dark side now. See, this this
Mm,
this is the legal side of things. Okay. In some states, some particular services are protected. Railroad corporations, public service corporations, and electric cooperatives are common ones because they act as a quasi-public agency, providing services to a larger part of the population than just individual interests. Tolling is the term that's applied to the period during which an adverse claim cannot run due to a handicap. It's an interruption, but it's not a cancellation of the adverse claim. For example, if Brown initiates a possession claim in the year 2000 against Black, and then Black's incarcerated at the seventh year and he's in prison for 5 years, okay, then that 5 year period, there's a stay on the possession, but as soon as he's back out again, then it continues at that point. So the ripe claims, the 20-year period is ripens in the year 2025 to make up for that 5 years that he was in prison for a term less than life. So tolling is the interruption; it's not a cancellation. Protected parties in most jurisdictions, the public, federal, state, and local government cannot be adversely possessed against. A public land can be adversely possessed in Wisconsin. There's a statute, 893.29, no adverse possession against the state or political subdivisions, no title interest, unless the adverse possession, prescription, or user continues uninterrupted for more than 20 years and is based on a continuously maintained fence, which has been mutually agreed upon by the current landowners. So basically, as long as the state agrees to my location of the fence, I can adversely possess state land for a 20-year period. So you can, in some jurisdictions, adversely possess public land.
Did you have that as a depends on your pop quiz?
That's why I had an it depends as one
Yeah,
of my choices for the answers.
I love it.
This is the one, and this is when I worked for NLC Prep. There was one of the questions that
Oh
adverse
yeah.
possession was you cannot adversely possess against the public, and I'd always go back. I tell them
Yep.
that's not true in Wisconsin. If you can prove the exception in one situation, you can't use a question like this. You're always protected. So
That's awesome.
whenever anybody in Wisconsin answers that question, they're gonna get it wrong. Okay, because in Wisconsin you can.
Sure, yeah.
Now, to break a claim is actually easier than to fulfill the claim because the title holder is expected to defend his or her title. The adverse claimant has to meet all those requirements for the entire period. But the title holder only needs one not to be met to protect the title. The title holder, the easiest way to break the title is to give permission to use the land. Because in most jurisdictions, I don't say all of them, but most jurisdictions, once permission is given, it exists until withdrawn. So if I see somebody using my land, he's been using it for 19 years and he's salivating, because I'm going to get it now. I go over and say, you're using my land, you got my permission to be using it. If I formalize it in that way, then that breaks his adverse possession. And he can't start all over again unless I remove that permission. So it's actually easier to break a claim as long as you do something about it. And there's particular state statutes that can help in that respect. We have a couple in Wisconsin called affidavit interruption, entry upon real estate to interrupt adverse possession, declaration of interest in real property and make it formal before a court. Say that's my property, he's using it. I want that to be a court action, and actions for possession of real property, damage for withholding. And some of these are also used by the adverse possessor that once all the elements have been met to lay claim legally to that title. Okay, now technically, as soon as all the requirements are met, adverse possession takes place. But normally it winds up getting fought out in court. The court reaches a decision that says, yes, all the conditions have been met. One of the contentions are, like, say, if it's a for 20-year period, it's got to be used for 20 years. Does that mean every single day that land has to be used by the adverse possessor? The use has to be in character with the land that's being claimed. Okay, so if it's agricultural land, it's working as agricultural land. You'd be, cultivating it, planting on it, harvesting on it, but then in the wintertime, you don't do anything with it. Right? So you don't have to be out there every single day using the land. It has to be in character of the land that's being claimed. That's something that would support. So now what? What happens to the descriptions of the involved parties? Okay, do the description suddenly change? Well, it depends. In the Wisconsin Court of Appeals, 1984, as in Brockman, we suggested that the parties provide for a permanent description by metes and bounds that can be inserted in the judgment to provide permanent settlement of the controversy. So in this case, they said here that, okay, adverse possession has taken place, but we suggest that you put together a metes and bounds description to reflect that so that it becomes part of what? The chain of title. Becomes part of the chain of title. So if somebody researches it now, if you're a surveyor researching this, you're going to run into that new description that's based on an adverse possession case that was determined by the court. Because the next description before that's going to be different. The part of the description before that, because that was before the adverse possession took place. So at that point, then, if you don't have that new description in there, you're going to see a discrepancy between what the deeds say, what the descriptions say, versus what's actually happening on the ground today. So we further, and this again, another Wisconsin court, we further direct that the trial court to quiet title to disputed land accordingly. Now, I didn't have a chance to search through a bunch of common law for a bunch of states and stuff to see if there are actually any states that, in fact, when adverse possession is adjudicated by the court, that rewriting the descriptions or updating them are actually part of the process or not, if that's mandated statutorily or by common law. But there are quiet title action statutes in most states, and the court may, like in this case, suggest that a quiet title action be done of some sort in order to clarify that and put it into the chain of title. Remember, adverse possession is a title matter, not a survey matter. Okay. The difference between the two is the title matter is the rights that are associated with ownership. A survey matter concerns corners and boundaries, and they can be depicted graphically on a map. Remember back that one graph like I showed you at the beginning, I said there were the deed corners, the ownership corners, and the possession corners. They all coincided. And at some point, based on the actions and the operations of the adjacent parties, they started to separate. Well, there's certain things that the surveyor can locate on the ground and make decisions about, but there are other things that he can't make decisions about. Adverse possession, we cannot determine if adverse possession has taken place. However, we can in fact document the difference between the deed lines, which would be the original title lines, and the possession lines that may serve as the basis for an ownership decision later on. The court may be basing their decision on it. So surveyors is equipped to interpret written intent, collect and evaluate evidence, and determine senior-junior relationships to reestablish boundaries, but not empowered to determine the state of unwritten rights, whether all those elements are present, whether they've all been met, and what the ownership status is. It's kind of, if we look at, and I'm sure most of the other states have got things like this, where it talks about resurveys in the state of Wisconsin or minimum standards. It says, in accordance, every property survey shall be made in accordance with the records of the Register of Deeds. The survey shall require data to retrace the record title boundaries such as deeds, maps, and certificates of title. Nothing in there says determine ownership based on unwritten means. It's everything that's a function of that description of that deed. By definition, unwritten rights are not in the records of the Register of Deeds unless the court says we have to update those descriptions, in which case they're no longer unwritten rights. They're written at that point. Okay, unless a quiet title action has occurred. And just kind of round this up here, rules of construction. If we look at the rules of construction, right at the very top, we have unwritten rights. Okay, that's where we've got adverse possession, parole agreement, recognition acquiescence, equitable estoppel. Those are matter of title. Okay. Below down, we've got written intentions of the parties. That's where the statute of frauds type of stuff comes into play. Call for survey, monuments, distance and direction, area coordinates, all that kind of stuff, the evidence that we collect. In the middle between those two is we got this thing that's called senior right in the event of an overlap. Okay. So when we saw that there was color of title, the east 200 and the west 200, and there was only 397 feet, we could feel pretty certain that we kind of know who's got the senior claim on there. But what if there's a gap in between them? If it's 402 feet, okay, does it go to the senior owner to the junior owner, or does it stay with the original title holder, or does it go? What happens to it? Senior right in the event of an overlap. When you get into gaps and that type of stuff, you start to get a little bit of murky, and even Brown and all the people that co-authored the book with them are inconsistent on that type of thing. So matter of survey, we feel comfortable with. Once you start crossing over to matter of title, that's where you have to have an attorney and you go over to the dark side of stuff. All right, adverse possession, remember, it's not a violation of statute of frauds. It's an ownership claim against title claim, and it ripens when all the elements have been met. Okay. Once it has been met and has occurred, it affects all subsequent landowners, and that's determined by a court. Surveyor collects boundaries and possession information, but does not determine if land is adversely possessed. All right, let's go back to our pop quiz. Number one, based on his or quasi-judicial capacity, the surveyor is able to render a boundary decision where adverse possession is involved?
False.
False. That one is false. There must be intent to possess for an adverse claim to ripen.
True.
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 Now, it depends.
It depends.
Remember, I showed you those different court decisions that had different degrees of what the intent was, right? Some say you had to have the intent. Some say you didn't. It could be an honest mistake or whatever. If you knew it was somebody else's land, it wouldn't have been the intent. So it depends. A court decision in a successful adverse possession will result in new property descriptions.
True.
I got a true. Do I have any other answers on that?
True.
True. I got true as all the place. No, it depends.
It depends.
Remember the case I gave you? They said that they suggested that they rewrite meets and bounds descriptions in order to clear that up in a written record. So it depends. The required time for adverse possession is?
It depends.
It depends.
It depends. There you go. You're getting the hang of this now. I didn't even bring out my magic 8-ball today. The same party must initiate and maintain the possession for the entire required time period.
False.
It depends.
It depends.
It depends. It depends. Depends on if it's based on constructive possession or actual possession in the jurisdiction. In Wisconsin, it doesn't have to be that case. Okay, if you have different time periods. In other states, you can't claim adversely unless you have constructive possession based on a defective title. Publicly owned land cannot be adversely possessed.
It depends
And
by the state.
I think it's true.
It depends by the state, okay? But that's technically false because in Wisconsin you can. But it depends, right? Possession based on a written document is called what kind of possession?
Be simple.
Two kinds of possession,
Um,
actual and constructive.
constructive.
Constructive is written on, is based on a written document. Remember, when you record a deed, that's constructive notice. That means there's a written document. Okay? A seemingly good deed which contains a description defect is said to have blank of title.
Color.
Color.
Color of title, right? On the face of it, looks good. And hostile requires intentional overt action.
False.
True.
It depends. It depends on the jurisdiction.
Ah,
Okay? See, this is why for some of these things, common law, even though there are statutes that address adverse possession in most states, it hits the highlights of the stuff, but there are a lot of things underneath that are still driven by common law. Okay, what constitutes use? What constitutes a handicap? And those types of things. So don't assume that because if you're familiar with the way adverse possession works in one state, that the next state over it's going to be the same way. Okay.
But
All right, so
bottom
that's
line, bottom line, it still involves the court, correct?
call a lawyer.
that's right. Yeah. In some states, it's easier to steal land than in others. Does title insurance insure against adverse possession?
It's. I'm sorry. I have a question because a lot of these questions that you're asking, like
Uh-huh.
the easy one is saying it depends. But I'm in Texas. We're like we have a lot of like boundary line agreements. Um, those get worked into title. They don't always like carry on. So it depends. I hear what I am saying. It
I was
depends
gonna
on,
say,
like, on the way it's written. If it goes to like if there's a sale or any other transaction
Well, see,
on that property.
yeah, see, the thing you gotta be careful, and it's difficult to make statements based on things like that from different jurisdictions
yeah.
and that
Yeah,
type of,
it's written
boundary
on
line
as I'm
agreements.
saying, and I'm like,
Are they if it's written that it could meet the statute of frauds, and it doesn't necessarily have to be recorded unless the state statute says in order for it to be legal, it has to be recorded. Now, not all state statutes say that, and all states have that. So again, it depends on the particular situation
but it could
in
be
your jurisdiction.
recorded. It could be recorded with stipulations in it, right?
I was gonna say, Summer, what's actually recorded in Texas?
Right.
Yeah,
I mean, it's
yeah.
such a thank
That's like,
you.
okay, that's like one of the questions early on was about a handshake agreement.
Yeah, that was Summer. Yeah.
Because
Yeah, it was also me.
one of the unwritten means of ownership clarification, boundary clarification, is a handshake. People can get together and say, "Look, we don't know where the boundary is between us, so let's just pick between the telephone pole and that maple tree back there. Is that okay with you? That okay with you? Handshake, okay." In some states, that's sufficient. In Wisconsin, the common law says it is unknown not to the owners, but to the surveyor. If a surveyor can find that boundary, then it's not an unknown boundary. So they can't make an agreement based on that as an unknown boundary. Now, in other states, it just has to be unknown in the minds of the two people that are involved.
And then when they die, it's a problem. Yeah. So I like it better the other
If it's
way.
not, yeah, that because there's nothing written unless they go
Yeah.
through some sort of quiet title action. And that's why I normally, that's when you go down to the Office Depot store or whatever, and you can buy a pack of quitclaim deeds for like, $5 for a pack of 20 of them or whatever. And you can fill those out, quit claim on each side of the boundary to each other. Then you've met the statute of frauds, and you can record that and bang it because it's part of the chain of title. Now, I'm not advocating everybody do that, but it's a step above just a handshake type of thing and then saying, well, I agreed with Joe Brown before he died that this was going to be the common boundary here. Because there's nothing to prove it. That's why we have a statute of frauds.
Or you can go a step further and do like Mr. Stahl and do mediation.
Sure. Yeah, I mean, there's all sorts of
Yeah, exactly.
ways to do it, to memorialize it,
Exactly.
so that everybody knows from this point forward what the situation is. But you want to do it in some sort of legal fashion, something that's got some bite to it, some law behind it and that type of thing, as opposed to the he said she said type thing, which is the whole reason we had the statute of frauds to begin with.
Can I ask another question about the and I don't know if this goes into like maybe eminent domain versus adverse possession, but we have a lot of cases here with like say like water features, like bayous or this type of deal where like there's like a county or agency that, even though say there was a fence that existed and the property owner's paying taxes and has paid taxes for, I don't know, 40 years or something on the property. The county comes in and they're like redefining the, I guess, the boundary of the water feature, or let's drainage feature, whatever you want to call it. That's where it gets super tricky because it's kind of like reverse order of some of the things that you talked about, where they're saying that the guy doesn't, he owns it, but they have use to it, but there's not a prescriptive easement associated with it. The boundary of that water feature is undefined because of erosion, blah blah blah. It gets so messy. Would that fall into this category as well? I mean, just not to go into so much detail in this particular conversation. I know there's not time, but I'm just trying to figure out how I can better learn how something like that might work, if that question makes sense.
Yeah, it depends. Yeah, it's a tough one because not only exactly what the type of stuff is that you're dealing with there, like say in Wisconsin, the beds of navigable lakes
Yep.
belong to the public, and the ownership ends at the ordinary high water mark. For navigable streams, however, the ownership belongs to the upland owner. So you're paying for taxes for on land that's underneath water that the public has the right to use that water. So that could be similar to like your water feature. And again, it's the ordinary high water mark that's used as the delineation, even though the water might not be up that high and that type of thing. So a lot of it depends on the type of water law that you have. And I'm not
Hmm.
that familiar with Texas. I know that you've got a couple different cultural influences
Hmm.
on ownership in general in Texas. And see, we use a lot of our water to make beer out of. I'm not sure what you guys do in Texas with your water. You probably do something silly like give it to feed it to cattle or something. Uh, but it would depend. I'd have to dig around on that some a little bit. If you have something, give me like an example or something like that. You want to send an email to me. I'll be glad to see if I can find some additional information on that.
Thank you.
I'd,
I appreciate that.
I'd like to talk about one thing that I don't think we've covered here tonight. Arkansas has a lot of adverse possession cases. That's very common. We've got a 7-year time period, and that probably has something to do with it.
Oh yeah, it's a free for all then.
But considering the number of cases that we've got, there's an issue there. Right at the start of this thing, we talked about what things have to be ticked off to satisfy adverse possession, and it may vary a little bit from state to state, but
Uh-huh.
it's pretty common. There's lots of little boxes. You check the boxes and find out whether you've got adverse possession or not. But there's a little bit of a problem there, and that is how you're going to evaluate it when almost every case I've seen that was an adverse possession, there was more than one action of the party to be evaluated. sometimes 4 or 5 things
Sure.
that a claimant is going to say, this cements my adverse possession. So are you going to take those 5 things individually, or are you going to take them in aggregate? In other words, if you've got 5 things and every one of those 5 things meets 4 of the requirements or almost all of the requirements, but there's one missing, one box you can't check on that particular usage that's claimed. But then you go to the other cases and that box does get checked. Well, is the court going to evaluate that looking at all 5 actions together, or are they going to take them one at a time and say, if this action doesn't check all the boxes, it's out. We'll go to the next one.
Well,
And that type of thing is a problem. A case that that I first ran on into the early 90s that was decided, appellate case, came out of 2 lake lots in Hot Springs, Arkansas, and one had been developed early, and the adjoining lot, had gone 20 years undeveloped. And they got into an adverse possession thing, and the surveyors for both parties agreed on where the lot line was. There wasn't any question there. The question was solely whether adverse possession had taken place or not. And you got into this thing about whether the different things would be taken as aggregate or individual. And this particular court, it took all of them in aggregate for the majority. It was a split decision at the appellate thing, and the majority held that all of the elements that had been brought forward would be considered, and they awarded a large part of this lot when the only thing that checked all of the boxes was one short little piece of concrete curb that went about 2 or 3 feet onto the adjoining lot. So it makes a tremendous amount of difference there.
Yep.
And I looked around at Arkansas, and we've got a lot of semi-rural subdivisions that were created by people that weren't good at selling lots, and a few of them the lots get built on, and then all the rest of them don't. And a lot of those lots are kind of small, and the houses get built within about 10 feet of the boundary line. And I could guarantee you, in all the surveying that I've done, you go into that situation, and the developed lot owner is going to trespass onto the adjoining lot to clear brush, cut trees, whatever, because that is a fire hazard to him. It's got mice and snakes over there too close to his house, and they will cross that line in every case. And if there's just one tiny little place on that lot line where a property owner could say, this checks all the boxes, he gets to claim maybe a large part of the lot. So I don't know, it's terrible law, but I see why it has to be done, because if you went through every little action and crossed it out, if it didn't check all the boxes, you never would have adverse possession. So in Arkansas, you go into one circuit court jurisdiction, and they're judging these cases as an aggregate. You go a few miles away in another court venue, and they're taking these cases and evaluate them as individual operations. So as a surveyor, you have to know what court you're in, or you're in trouble. The other thing is that it can be said. I know a lot of surveyors say, I'm not an attorney. I don't make those opinions about whether adverse possession took place or didn't, or whether it was this or that or acquiescence or whatever. But the truth of the matter is that we operate in a law element. And there's a lot of cases where professions overlap. Dentistry overlaps with medical field. Engineers overlap with architects, and surveyors overlap with lawyers. There's things that we do that you either need to be either a surveyor or a lawyer to do. When a surveyor issues a survey, it's just an opinion. It carries no weight. It's not binding on anybody. If you look at Arkansas law, go to the place in Arkansas where we now have all of our plats online. And the first thing that tells you right there that these plats don't mean anything. They serve two purposes. They show what was done and who did it. And beyond that, surveying has no authority whatsoever. All you're doing is issuing an opinion as to the boundary line. It's not binding on anybody, and you can make that opinion freely. And to tell the truth, I have never seen a surveyor who had to pay off on a suit that was about boundaries. You issue that, it's just almost impossible to be successful in suing a surveyor over a boundary, because what he's doing is he's giving you an opinion as to where that boundary is at. And everybody that I come in, my clients that come into me, I ask them, what is it that you want to know? Do you want to know where your deed says your property is out there? And he says, yeah, that's what I want to know. Realize this, I tell him, that may be what you own, but it quite probably isn't. What do you mean that's not what I own? Well, there can be conflicting deeds, there can be actions of the adjoining landowners, any number of reasons that you don't own that particular piece of property that's described in your deed. And he says, I want to know what I own. That's what he wants from me, is an opinion as to what he owns. It's not binding on anybody, but it's an opinion that I hope that I can take to court and win with.
James, we've missed your wisdom. James used to be on Wisdom Wednesdays all the time in our books, but not so much lately. But yeah, I love it. Jerry,
I got I got one more thing I want to share.
Yeah, please.
Do you see this interesting conversation slide?
Yeah.
Okay. This is an actual email correspondence, slightly reformed and slides, but no other editing was done. I was contacted by surveyor in northern Wisconsin, and he said he got a call from a surveying instructor in Nebraska asking if I have a license in Minnesota. He was buying lake property on Bemidji Lake in northern Minnesota and believes there may be an encroachment. Okay, the following is an actual email from him to his attorney and then the attorney's response. Okay? So he says, dear attorney, I still have a concern about possible encroachment on the property. We are purchasing an encroachment, maybe the garage to the north, encroaching on the north property line of either by physical location or the overhang of the garage roof encroaching over the property line. What are our options? So the title company doesn't have a concern because it's cash purchase. Is there something that I can put in the purchase agreement now that will indicate there are no encroachments on the property? The title company indicated that the only way to determine if there is an encroachment is to have a legal survey done on the property. In most states, that is encumbered by the seller. So the seller pays for the property survey, right? How about Minnesota? It may be as simple as having a mortgage survey completed and signed by a registered land surveyor. I would hate to find out later in life that there's an encroachment and I have to hire an attorney again to fix the problem. Most encroachments in most states halt the sale of property until the encroachment is fixed. Is that true? No. Please answer this email before we make the final purchase of property. Okay. Unfortunately, the attorney we discussed this with here in Nebraska indicated the encroachments are serious business. Unfortunately, he cannot conduct business in Minnesota, but he is the dean of law here at the school in Nebraska. Okay. So this is a surveying instructor that's asking all these questions about encroachment. The attorney writes back, well, leads you to believe there's an encroachment. Encroachments are rather common in Minnesota Lakeshore. Because lots are small, the lot lines are not well defined. People don't want to spend money for surveys up here. There's an expensive house on a lake, built over half line. That went with the litigation. And frankly, it's nothing. If there's an encroachment, the garage has been there less than 16 years. You could force your neighbor to correct the encroachments. Not a good means of making neighbor. So basically, you had a surveying instructor. It was a 4-year program in Nebraska, asking questions that made absolutely no sense with respect to encroachments and stopping property surveys and mortgage surveys and that type of thing. And the dean of law telling them that really there could be a problem, but I can't answer that for you. You have an attorney in Minnesota tell you, no, you told him the attorney in Minnesota saying, encroachments, no big deal, lakeshore property, it's small lots, nobody concerns about that. Okay. So basically, and I don't know if you wound up buying land or not, but I told this surveyor from northern Wisconsin, stay away from this. Stay away, don't get involved with this at all, because you got potential adverse possession case, and the attorney's saying nobody really cares, and all these lots are small anyway, and they're big, expensive houses on lakeshore. But this is some of the most expensive land in Minnesota is on lake shores and that type. So it's a comedy of errors, and like you were saying there, it's whoever makes the strongest case in court, whoever acts most like the owner and asserts the rights as the owner of that land is going to make the strongest case for adverse possession. He may not tick off every single one of those requirements, but those requirements that he does tick off that shows that he's acting, particularly if it's in good faith, as the owner of the property, is going to have a strong case with respect to it. So, but whenever you go into court, it's whoever the attorney is that argues the best. And it doesn't matter if it's the attorney that you got has got the principles on his side, if the other attorney makes a better impression on the court and throws out case law and all this kind of stuff, it doesn't matter what the principles are in some case. Whoever makes the best argument. So it's
It
that's
depends.
why that's why that's a dark side. You know, that's why we go to the stop sharing. Stop share. Okay. I'm sorry, I got on my soapbox there a little bit, but
No, I love it. Yeah, there's soapboxes are loaded full of knowledge. Yeah, that's good stuff.
anyway. Any other questions, comments, observations? Nope, that's it. You're all experts now.
Well, I mean, there's one thing I just want to say that I don't know if you'll have like the pincushion effect, but I mean, and most of these like our books do cover a lot of this. That I mean, like the law is not anywhere absent in any of it. I mean, I don't subscribe to the whole it's not our problem. I mean, if we don't understand, we're not doing um it'll come back and bite you in the tail. So but I mean it's half of this. So I just like open it up because I had some.
Yeah, it's recognizing where you can and can't make decisions, and when it's time to engage an attorney or have the client engage an attorney because now you've gone on the legal side. It's a matter of title now as opposed to a matter of survey. It's something you can't throw technology at to solve. Okay.
Mm.
And no matter how well you measure, how expensive your equipment is and stuff like that, these are not questions that technology can solve. It's something that only the courts can solve. And they're going to base it on, common law, what the tradition is, what the previous court decisions were. They're going to try to maintain some degree of consistency. It's that stare decisis you hear about all the time, that the lower courts are supposed to make decisions, consistent with the way the higher courts define common law principles and that type of thing. If you guys haven't used Google Scholar yet, I strongly encourage you to do so. That's the way I do a lot of research with some case law in different states and that type of thing. But you can go in there and go into your state and select both the federal and the state courts, appellate level courts, and search on things, search on adverse possession, search on some of the water features type of thing, situations. You'd be surprised at how many things get turned up. And it's like when you look at definition in a dictionary, you see another word that piques your interest, you start following that. And they've got all these hot links and all these court cases that link to other court cases. And before you know it, you're down a rabbit hole and that type of thing. But there are a lot of things you can find out just on it. It's not like a full legal library and that type of thing, but it gives you a flavor for some of the things that are going on out there, particularly in your jurisdiction. Or if you are one of these people that collects licenses from different states and that type of thing, you want to be familiar with those legal concepts in those other jurisdictions also. Don't just assume that because it's 21 years in Pennsylvania, where I'm from, there's going to be 21 years everywhere else. Okay. That common law stuff, that's part of your responsibility for understanding as a surveyor. What are some of the common law principles that we have to operate under? And the fact they aren't necessarily the same jurisdiction to jurisdiction. Google Scholar, use it.
So do you click on so I'm in it now. So do you this is great. I did not know this existed. So you go into your state and then just select all of I don't know about criminal appeals, but that you have to search the federal and then the state separately, it looks like.
You can select both state and federal, and you can select multiple states at the same time also.
Okay, great. Yeah, this is great.
So,
Thank
but
I
I
just threw it
I
in the
normally
chat.
will start. Usually, the stuff that you want to search for is the state courts, because that's within the state. Anything that's federal is going to be dealing with the federal agency or cross state boundaries and that type of thing. But if you
Mhm.
want to look at what your common law is within your state, just select all the appellate level court cases in your court in your state, and then just start typing in terms. Okay. And sometimes you'll get a good hit it, put adverse possession in there. I'll guarantee you'll get a 100, 200, 300 hits on stuff in there. And they'll range all the way from current stuff back into the 1800s.
Excellent, excellent.
Mhm.
Thank you.
Yep. Yeah, we almost have to talk about that almost every week. I know we've brought it up a few times, and I know Jerry's brought it up probably every presentation he's done, but
It, it's
it
it's
just
almost it's almost worth at some point just to
yeah.
have one session where we can go in there and just kind of play around with stuff and see what kind of things you can dig up.
Um,
Just to show what the differences are between different jurisdictions.
And
That's some of the stuff, these common law stuff that I got in this presentation here is I picked a couple random states as a group
yeah.
and it did adverse possession. So I'd get Washington hit, Nebraska hit, Pennsylvania hit, and all that kind of stuff. And I could immediately compare one against the other, looking at what some of the different requirements are.
Jerry just made his September 2026 presentation.
Oh yeah, sure.
And Steve Martin threw in the chat. Curtis Brown had a good one in 1979 article on land surveyors' liability to unwritten rights. Of course, we know all of Brown's writings, but those he's full of them. That's for sure. He's full of them. So and so much good information that come from Brown. So
Yes.
anybody else? I love it as always. Great job, Jerry.
Everybody's any questions? Feel free to contact me.
Yeah. James,
Thank you
great to
so
see you
much.
again.
Have a cheap date.
We'll have one more this month, and then we'll be off for the Christmas break. And then we got kind of a full slate going next year already. February is all about Gary Kent, and we're going to do ALTA standards because the 2026 standards are coming out. So January is going to be all about business and safety as well, as I always normally do. So I threw Jerry's email in the chat. If anybody needs something, let me know. But I love it as always, Jerry. I appreciate your time and your passion, and thank you for not fully retiring yet. Have a great,
Thank you, Jerry.
Thank
yeah,
you
of
Thank you,
so
course.
Rex.
much.
Have a great
Thank you,
weekend, everybody.
guys.
We'll chat
Good
soon.
night.
Bye, guys.
Bye.
Mhm.